Well, hello everybody. Welcome. Bonjour. On revient en français à 11h, souhaitant que j'ai pas de retard. So anyways, welcome again to another Saturday session. It's 10 a.m. on Saturday, March 9th. I can't believe I blinked and we're already March 9th. It's like, oh my God, we don't have enough time in the day to do anything or to even think properly. But time is flying by. And I think this weekend we move ahead to spring. So we're going to be bringing our clocks forward. Okay. So just a little reminder there, I think. But anyways, I think it was for this, last night actually. But anyways, hopefully, things will get a little bit brighter longer during the day. I shall enjoy the sun. But anyways, I wanted to discuss again today. It's not just a possibility that Canada will be charged with Canada. Well, actually, it's Canada and Canadians. We will be charged because we're stuck with the purse strings and having to pay for every atrocity that our Canadian government does. So there's proceedings right now against Canada for aiding and abetting Israel for selling, missiles, or I don't know, not missiles, but military equipment, whatever it is, as long as it helped Israel to continue their assault on Palestinians, then we are liable. And the thing is, they had said, Canada said that, oh no, we didn't send them any military equipment. Doesn't matter. It goes back to 1967. Okay. And it hasn't stopped. The atrocities in Palestine hasn't stopped. And anybody who thinks that Israel is in the right here, you need to look at history, because Israel was used by the UK, the US to bring the Jewish people there, okay, to be against the Palestinians and to take over the entire territory so that they could persist their wars against the other countries who have oil and gas and things like that. So you need to understand the history there. This is not about religions. This is about natural resources. This is about corporations and feeding them. And they actually used the Jewish people to say, oh, well, we need to defend our Jewish people. We need to, against, how did Hamas begin? I mean, Palestinians needed to be protected. Is Hamas right? No, neither one is right. But right now, between Hamas and the government of Israel, neither one is right. But who's stuck in the middle but the Jewish people and the Palestinians? So right now, court cases are launching. There was a court case, a presentation at the International Court of Justice in regards to charging Israel with genocide. Then the UK, Canada, and the United States, as well as I think now they've included Germany, and I'm sure they're going to include France because France gave Israel a nuclear reactor for nuclear warheads. So all of these countries are going to be charged. And the thing is it's we, the people, that are going to be responsible for this. We, the people, are going to be looked at as, doing these atrocities. And the irony is that our own government has taken actions against us that should be charged with crimes against humanity, or crimes against Canadians anyway, and humanity, because whoever was here in this country, visiting this country, who had to even give a PCR test, their DNA was stolen. So the whole thing about the last 3 years was about DNA collection. And nobody's really talking about that, but that's the big coup d'etat in the sense of our DNA, and without letting us know what they were going to do with this, without consent. So, it's one thing after the next. And did it start with the liberal government? No, it did not. It started with, they're all part and parcel responsible for this, and their votes in government has to be looked at. So are the senators guilty as well as the parliamentarians? Hell yeah. So they're going to wake up pretty soon and see that the international will be charging these people, and who knows who's going to end up in jail. So we're going to see exactly what these countries now have done. So there was the first charge of genocide, and that the countries spoke in regards to that, and then another charge. 50. There was 57 filings in regards to crimes against humanity and crimes of apartheid, which was, if you listen to very well to the words that were being said in the sessions that we've shown you. But there's one session in particular I would like to focus on. Okay. And right now I'm not seeing what you guys are saying. So, okay. So good morning, everybody. But anyways, not the bearer of bad news here, but in a roundabout way, what happens to Canada in these trials, this wasn't a trial. This was just when they went to the international court. It was just to be able to say to the court, yes, you have the right to proceed and give us your deliberations. So what will happen afterwards is a mystery. It seems pretty definite that yes, genocide was committed, and crimes against humanity and apartheid. There's no argument there in regards to that. And the people who are responsible are just going to have to suck it up and make do for what they've done. And the thing is when I talk like this, we allowed our governments to do this. That's why we're going to be implicated as well. So because we didn't stop our governments from interfering in Palestine since the beginning, and it's not like we didn't know. I remember 6 years ago going to Toronto in regards to a seminar that was given in regards to what was happening to Palestine. And I was shocked. I think it was more than 5 years ago, so I'd say 6. And it was just appalling to see this. And then it kind of looked like what they did with the indigenous nations here. So it was like a rude awakening. But anyways, what our government does is in our name. Are you okay with that? Don't you think that it's time that we took action and stopped allowing this government to do things in our name? Because now we've got blood on our hands too. That's the sad reality. And it's not just here. It's not just in Palestine. It's wherever our Canadian government went. Every time that they participated, in The video that I showed yesterday, the young military guy says, we're going to war against poor people in countries who can only throw rocks. Seriously? Those are the wars they're going to? Canada is tied by the belly button to the United States military. Paul Martin started selling off our military, boots and all, and then Stephen Harper finalized it. And our military takes its direction from the United States. If there's Chinese people here doing military practicing, well, who do you think allowed them in? Because the United States military is in charge of everything around Canada. The water, the air, and land. So, NORAD. So everything that happens here, the U.S. military knows about, because they have to give their permission, because they're responsible for protecting all of the North American hemisphere. And everything the United States will do, we're getting sucked into that BS as well. So, but I really want to, I know I've showed, segments of what's going on at the international level in regards to these charges, and we're going to be slapped really hard with this, really hard. And the realization every time somebody dies in Palestine here on in, like since the beginning, that gets counted to our charges. So we really, really need to understand what's going down. But we need to make it clear to the government and to the countries that we do not support what our government has done. I've never supported that. I would never have supported that. Ever. Because the rules of war, they're supposed to be fighting somewhere else and not where civilians can get hurt. That's the rules of war. So I want to show you the one thing that really, everything that we've said since the beginning in regards to self-determination of countries and the people's rights is exactly, they reiterate it every time one country speaks. They reiterate what we've been saying all along, that in our country, we have the right to self-determine as many times as we want. So do the Palestinians. It's not just a one-time thing there. We've never been properly decolonized, because as long as we have Charles as the head of state, we will never get our rights. It's time to remove Charles. Are you with me? So anyways, it's time that we take back our power, as well as veto rights in case our government goes rogue. So right now, Canadians only have the right to vote for our next dictators every 4 years. That's the only rights we have, because they can take away all of the other rights whenever they feel like it. So let's make sure that the Palestinians and Canadians and everybody worldwide, even the Jewish people, the Israelis, all place the people in power above rogue governments who are creating wars. Because the CPU solution, there would be no need for wars. There would be no need for corruption. Like, corruption would almost die down, because you can't corrupt 40 million people or anything greater than that. So once the people would have the right to veto what our government does, before it does it, they'd have to present especially on something that affects us all, which is what they were supposed to do to begin with, because in a democracy, you're supposed to have referendums. Well, most of them give out referendums that mean nothing. Okay, because it's the governments that are in charge of assembling the referendum. So careful of the question. And but the people need to be in charge here of our referendums and things, because it is our power. We own the political power, and we need to take that back. So our governments will finally be working for us, and not us working for a government that can do whatever it wants to us. So I'm going to play this. It'll be about 20 minutes. I know it's a little bit long, but I want you I want to do this to be able to explain at least one segment, and this is the most important one, because we can have our freedom if we want to, but you need to understand that there's a certain way of doing it, and there's a certain way of debating it. And that's why joining the CPU as a member right now is absolutely needed before we are too late and we start getting attacked because of what's happening. Okay. And we don't know how Israel is going to react once the gauntlet falls, or the USA and the UK. So we might be thrown into an all-right war, which the USA has already declared could happen. They want all the countries to spend what they need to on military equipment and be ready for 2025. So now this is in our hands. We need to clean up the mess, and we need to do it right. So please stay tuned. I'm going to start this. And listen, take notes. Please take notes, because what you're going to be hearing, that works for us too, and everybody worldwide. And as long as if the people can be in charge of our governments, it's the only way we're going to finally have true peace and prosperity. Okay.
Of this occupation, acts of genocide, ethnic cleansing, war crimes, crimes against humanity, displacement of populations, imprisonment of Palestinians behind illegal segregation walls, expansion of illegal settlements, creating new political realities on the ground, aiming at complicating the dismantling of the occupation. All will never discourage Palestinians from claiming their legitimate, inalienable rights. The insistence on placing Israel above the law through the politicization of accountability and adopting double standards in the application of justice is a direct threat to international peace and stability. Ending Israel's total impunity and subjecting it, like any other state, to the universal rules of international law will help annul its pretexts to systematically reject peace initiatives, the most serious of which is the Arab Peace Initiative of 2002, which offered full normalization of relations with all Arab states in exchange of Israel only respecting its already established obligations under the bodies of international law, human rights laws, and the United Nations Security Council and General Assembly resolutions. This prolonged occupation is an affront to international justice. The failure to bring it to an end has led to the current horrors perpetrated against the Palestinian people, amounting to genocide. There can be no moral or juridical justification for occupying lands, killing, terrorizing, and displacing their populations. The League of Arab States trusts the esteemed court will confirm the illegality of this occupation and unambiguously rule on the legal consequences for all parties, especially those who turn a blind eye, facilitate, assist, or participate in any way in perpetuating this illegal situation. Only the rule of law, not the prevailing law of the jungle, will pave the way to peace in the whole region. Ending the occupation is the gateway to peaceful coexistence. Thank you very much for your kind attention. I now respectfully request, Mr. President, that you call on Dr. Ralph Wild, Senior Counsel and Advocate, to address the legal questions before the Court. Thank you.
I thank Mr. Al-Rifai. I now give the floor to Mr. Ralph Wild. You have the floor, sir.
Mr. President, distinguished members of the Court, It's a great honour and privilege to appear before you and to represent the League of Arab States. The Palestinian people have been denied the exercise of their legal right to self-determination through the more than century-long violent, colonial, racist effort to establish a nation-state exclusively for the Jewish people in the land of mandatory Palestine. When this began after the First World War, the Jewish population of that land was 11%. Forcibly implementing Zionism in this demographic context has necessarily involved the extermination or forced displacement of some of the non-Jewish Palestinian population, the exercise of domination over and subjugation, dispossession and immiseration of remaining non-Jewish Palestinians, the emigration to that land of Jewish people, regardless of any direct personal link, and the denial of Palestinian refugees the right to return, all operating through a racist distinction privileging Jewish people over non-Jewish Palestinian people. This has necessitated serious violations of all the fundamental Jus Cogens and erga omnes norms of international law. The right of self-determination, the prohibitions on aggression, genocide, crimes against humanity, racial discrimination, apartheid and torture, and the core protections of IHL. Today, I will address, first, violations of international law arising out of the regime of racial domination, apartheid, perpetrated against the Palestinian people across the entire land of historic Palestine. And then, second, the existential illegality of Israel's occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, since 1967. As a necessary prerequisite, I must begin with the special right granted to the Palestinian people in the League Covenant. The legal right of self-determination of the Palestinian people originates in the sacred trust obligations of Article 22 of the League Covenant, part of the Versailles Treaty. Palestine, an A-class mandate under British colonial rule, was, after the First World War, supposed to have its existence as an independent state provisionally recognised, a sui generis right of self-determination. The UK and other members of the League Council attempted to bypass this, incorporating the 1917 Balfour Declaration commitment to establishing a national home for the Jewish people in Palestine into the instrument stipulating how the mandate would operate. However, the Council had no legal power to bypass the covenant in this way. It acted ultra vires, and the relevant provisions were legally void. There was and is no legal basis in that mandate instrument for either a specifically Jewish state in Palestine or the UK's failure to discharge the sacred trust obligation to implement Palestinian self-determination. After the Second World War, a self-determination right applicable to colonial peoples generally crystallized in international law. For the Palestinian people, this essentially corresponded to and supplemented the pre-existing covenant right regarding the same single territory. The 1947 proposal to partition Palestine was contrary to this, the Arab rejection and affirmation of the legal status quo. In 1948, then, Palestine was, legally, a single territory with a single population enjoying a right of self-determination on a unitary basis. Despite this, a state of Israel specifically for Jewish people was proclaimed in 1948 by those controlling 78% more than 3/4 of Palestine, accompanied by the forced displacement of a significant number of the non-Jewish Palestinian population, the Nakba catastrophe. This illegal secession was an egregious violation of Palestinian self-determination. Israel's statehood was recognized, and Israel admitted as a UN member despite this illegality. Israel is not the legal continuation or successor of the mandate. This violation of Palestinian self-determination is ongoing and unresolved. Two key elements are, first, Palestinian people not displaced from the land proclaimed to be of Israel in 1948 and their descendants have been forced to live as citizens, presently they constitute 17.2%, of a state conceived to be of and for another racial group, under the domination of that group, necessarily treated as second class because of their race. Second, Palestinian people displaced from that land and their descendants cannot return. These are serious breaches of the right of self-determination, the prohibitions of racial discrimination and apartheid, and the right of return. They must end immediately. As if this ongoing Nakba was not catastrophic enough, in 1967, Israel captured the remaining 22% of historic Palestine, the Gaza Strip and West Bank, including East Jerusalem, the Nakba. It's maintained that use of force to remain in control for the 57-year period since. For more than half a century then, a state defined to be of and for Jewish people exclusively has governed the entire land of historic Palestine and the Palestinian people there. And the regime of racial domination, apartheid, and denying return has been extended throughout. In the case of Palestinians living in the occupied territory, this has involved the same serious violations of international law, supplemented by serious violations of norms applicable in occupied territory. Indeed, these people are subject to an even more extreme form of racist domination, as they aren't even citizens of the state exercising authority over them. Even in East Jerusalem, which Israel has purported to annex, the majority non-Jewish Palestinian residents don't have citizenship, whereas Jewish residents, including illegal settlers, are citizens. Just as in territorial Israel, in occupied territory, these serious violations concerning how Israel exercises authority over the Palestinian people must end immediately. However, here, a more fundamental matter must also be addressed: the illegality of the exercise of authority itself. The enduring Palestinian right of self-determination means that the Palestinian people and the state of Palestine, not Israel, are sovereign over the territory Israel captured in 1967. For Israel, the land is extraterritorial and, given what I said about the mandate, territory over which it has no legal sovereign entitlement. Despite this, Israel has purported to annex East Jerusalem and taken various actions there and in the rest of the West Bank, constituting de jure and de facto purported annexation, including implanting settlements. It is Israeli policy that Israel should be not only the exclusive authority over the entire land between the river and the sea, but also the exclusive sovereign authority there. This constitutes a complete repudiation of Palestinian self-determination as a legal right, since it empties the right entirely of any territorial content. Actualizing this through de facto and de jure purported annexation is, first, a serious violation of Palestinian self-determination, and second, because it's enabled through the use of force, a violation of the prohibition on the purported acquisition of territory through the use of force in the law on the use of force, and so an aggression. Serious violations of further areas of law regulating the conduct of the occupation are also being perpetrated, notably the prohibitions on implanting settlements and altering, unless absolutely prevented, the legal, political, social and religious status quo. The occupation is therefore existentially illegal because of its use to actualise purported annexation. To end this serious illegality, it must be terminated. Israel must renounce all sovereignty claims and all settlements must be removed immediately. However, this is not the only basis on which the occupation's existential legality must be addressed. We need to delve deeper into both the law of self-determination and the law on the use of force. Beginning with self-determination, this right, when applied to the Palestinian people in the territory Israel captured in 1967, is a right to be entirely self-governing, free from Israeli domination. Consequently, the Palestinian people have a legal right to the immediate end of the occupation, and Israel has a correlative legal duty to immediately terminate the occupation. This right exists and operates simply and exclusively because the Palestinian people are entitled to it. It does not depend on others agreeing to its realization. It is a right. It's a repudiation of trusteeship, whereby colonial peoples were ostensibly to be granted freedom only if and when they were deemed ready because of their stage of development determined by the racist standard of civilization. The anti-colonial self-determination rule replaced this with a right based on the automatic, immediate entitlement of all people to freedom, without preconditions. In the words of General Assembly 1514, inadequacy of preparedness should never serve as a pretext for delaying independence. Some suggest that the Palestinian people were offered and rejected deals that could have ended the occupation, and therefore Israel can maintain it pending a settlement. Even assuming arguendo the veracity of this account, the deals involved a further loss of the sovereign territory of the Palestinian people. Israel cannot lawfully demand concessions on Palestinian rights as the price for ending its impediment to Palestinian freedom. This would mean Israel using force to coerce the Palestinian people to give up some of their peremptory legal rights, illegal in the law on the use of force, and necessarily voiding the relevant terms of any agreement reached. The Palestinian people are legally entitled to reject a further loss of land over which they have an exclusive legal peremptory right. Any such rejection makes no difference to Israel's immediate legal obligation to end the occupation. Turning to the law on the use of force, Israel's control over the Palestinian territory since 1967 as a military occupation is an ongoing use of force. As such, its existential legality is determined by the law on the use of force, as a general matter, beyond the specific issue of annexation. Israel captured the Gaza Strip and West Bank from Egypt and Jordan in the war it launched against them and Syria. It claimed to be acting in self-defense, anticipating a non-immediately imminent attack. The war was over after 6 days. Peace treaties between Israel and Egypt and Jordan were subsequently adopted. Despite this, Israel maintained control of the territory, continuing the use of force enabling its capture. Israel's 67 war was illegal in the Jus ad bellum, even assuming, arguendo, its claim of a feared attack. States can't lawfully use force in non-immediately imminent anticipatory self-defense. Alternatively, assuming, again arguendo, that the war was lawful, the justification ended after 6 days. However, the Jus ad bellum requirements continued to apply to the occupation as itself a continuing use of force. In 1967, with self-determination well established in international law, states could not lawfully use force to retain control over a self-determination unit captured in war unless the legal test justifying the initial use of force also justified, on the same basis, the use of force in retaining control. Moreover, this justification would need to continue not only in the immediate aftermath, but for more than half a century. Manifestly, this legal test has not been met. Israel's exercise of control over the Gaza Strip and West Bank through the use of force has been illegal in the Jus ad bellum since the capture of the territory, or at least very soon afterwards. The occupation is therefore, again, existentially illegal in the law on the use of force and aggression, this time as a general matter, beyond illegality specific to annexation. To terminate this serious violation, the occupation must likewise end immediately. What of Israel's current military action in Gaza? This is not a war that began in October 2023. It's a drastic scaling up of the force exercised there and in the West Bank on a continual basis since '67. A justification for a new phase in an ongoing illegal use of force cannot be constructed solely out of the consequences of violent resistance to that illegal use of force. Otherwise, an illegal use of force would be rendered lawful because those subject to it violently resisted. Circular logic with a perverse outcome. More generally, Israel cannot lawfully use force to control the Palestinian territory for security purposes pending an agreement providing security guarantees. States can only lawfully use force outside their borders in extremely narrow circumstances. Beyond that, they must address security concerns non-forcibly. The USA, UK, and Zambia suggested here that there is a sui generis applicable legal framework, an Israeli-Palestinian lex specialis. This somehow supersedes the rules of international law determining whether the occupation is existentially lawful. Instead, we have a new rule justifying the occupation until there is a peace agreement meeting Israeli security needs. This is the law as these states would like it to be, not the law as it is. It has no basis in Resolution 242, Oslo, or any other resolutions or agreements. Actually, you are being invited to do away with the very operation of some of the fundamental peremptory rules of international law itself. As a result, the matters these rules conceive as rights vested in the Palestinian people would be realized only if agreement is reached and only on the basis of such agreement. At best, if there is an agreement, this means one that need not be compatible with Palestinian peremptory legal rights, determined only by the acute power imbalance in Israel's favor. At worst, if there is no agreement, this means that the indefinite continuation of Israeli rule over the Palestinian people in the OPT on the basis of racist supremacy and a claim to sovereignty would be lawful. This is an affront to the international rule of law, to the UN Charter imperative to settle disputes in conformity with international law, and to your judicial function as guardians of the international legal system. A final potential basis sometimes invoked to justify continuing the occupation should be addressed. Occupation and human rights law, applicable to illegal and lawful occupations alike, oblige Israel to address security threats in occupied territory. However, they only regulate the conduct of an occupation when it exists. They don't also provide a legal basis for that existence itself. Existential legality is determined by the law of self-determination and the jus ad bellum only. There is no backdoor legal basis for Israel to maintain the occupation through the imperatives of occupation and human rights law. In sum, the occupation of the Palestinian Gaza Strip and West Bank, including East Jerusalem, is existentially illegal on two mutually reinforcing bases. First, the law on the use of force. Here the occupation is illegal both as a use of force without valid justification and because it's enabling an illegal purported annexation. As such, it is an aggression. Second, the law of self-determination. Here, it's illegal again because of the association with illegal purported annexation, and also, more generally, because it is quite simply an exercise of authority over the Palestinian people that by its very nature violates their right to freedom. This multifaceted existential illegality involving serious violations of peremptory norms has two key consequences. First, the occupation must end. Israel must renounce its claim to sovereignty over the Palestinian territory. All settlers must be removed immediately. This is required to end the illegality, to discharge the positive obligation to enable immediate Palestinian self-administration, and because Israel lacks any legal entitlement to exercise authority. Second, in the absence of the occupation ending, necessarily everything Israel does in the Palestinian territory lacks a valid international legal basis and is, therefore, subject to the Namibia exception, invalid. Not only those things violating the law regulating the conduct of the occupation. Those norms entitle and require Israel to do certain things, but this doesn't alter the more fundamental position from the law on the use of force and self-determination that Israel lacks any valid authority to do anything, and whatever it does is illegal, even if compliant with or pursuant to the conduct regulatory rules. I will close by quoting Palestinian academic and poet Rifat Al-Ariyah from his final poem posted 36 days before he was killed by Israel in Gaza on the 6th of December 2023. If I must die, you must live to tell my story. If I must die, let it bring hope. Let it be a story. Thank you for your attention.
I thank the delegation of the Arab League for its presentation. And before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.
Bon, un instant, là. 1 minute, please. I just got to go make sure to stop this. Okay. Now, we're back. And I hope that you appreciate what you just heard, because we've been saying this all along, not just for our country, but for all countries worldwide. We all have this right. And our International Bill of Rights is not recognized in countries like Canada and the other 14 countries worldwide that sit under the Commonwealth realm of nations. Okay, the Commonwealth realm. And those are our 15 nations that are now sitting under the Commonwealth that were all controlled by the UK at some point. 1931, what happened was, instead of liberating us, they created a new type of parliament with all of our heads of states, all of our prime ministers, who are the ones deciding at the Commonwealth what we can and cannot do in our countries. I don't know if you remember the video that I made in regards to Paul Salambier, who actually did a story in what they call the loophole for the Commonwealth realm. Okay. I was able to contact him, and he gave me his research in regards to how laws are supposed to be created. They're not supposed to have loopholes. Okay. They're supposed to be direct, and certainly not created as the laws are created here in Canada or the other countries, by using words that allow our governments to be able to corrupt the laws. This is what we've been doing at the CPU while everybody else has been busy doing other things, because the laws are supposed to protect us. But they don't protect us in Canada or the UK or Australia or New Zealand the way they should. Here, the lawyers have told us we don't recognize international law if the law has not been made in Canada as a national law or provincial law. That is false. That has been something that they have placed on the Canadian government website since 1982. Hasn't changed. International law, all of our rights, which constitutes 470 pages of our rights, plus documents called the Syracuse Principles and the Johannesburg Principles, were incorporated even by some of our justices here in Canada throughout the years. And these were justices who were all brought together worldwide to make sure that our governments did not take advantage of our rights. The Syracuse and Johannesburg principles were created to make sure that governments did not overstep their rights over the people. We are the political power. We have the right to take back that power. We don't even need to ask anybody's permission, but we need to do it right so it stands up under the legal tests. And that's what the CPU is about. That's what the Convention of Consent is. And that's what we need to do to be able to place the people above our governments with final decision-making authority, instead of giving of what Pierre Elliott Trudeau did in 1982, which is give it to the government itself and the parliamentarians, and not to the people. Our rights were stolen in 1982 again. So what do you want to do? Do you want true freedom, or do you want an illusion of it? And then only for them to take away our rights whenever they feel like it. The international law rights, they cannot take away. And the reason for that is because once they sign at the international level, the government and everybody underneath who is in a superior position above the people are liable. And this is what's happening now. What you just saw could be done here. Only the international level can determine if they're guilty or not of robbing us of our rights, because in Canada, we do not have those laws to protect us. No government, no new government replacing the existing government right now, say Conservatives come in, cannot, the only way that they can reject and say that they're walking away from the United Nations and all of these contracts they've signed would have to go to a referendum. But in Canada, the law states that a Canadian government cannot make a law that another government cannot destroy, except at the international level. So, in a roundabout way, the rights signed at the international level stating that colonialism was to end and the people were to exercise their type of governance that they so choose, and to take back all of their natural resources, has been hidden from us. So I will leave you with that. And I hope that all of the parliamentarians see this video and understand that they can all be charged, because under the Statutes of Rome, 2001, Chrétien signed off their immunity rights. But even with that, because the Crown is bound to our international laws that they've signed on to protecting the Canadian citizens, they can be charged with under superior authority. They can all be responsible and be locked up. And that's the truth. So I leave you with that. There is a light at the end of the tunnel. If Canadians understand what the CPU is about, you can see it on our website. You can go and read it. But if you want change in Canada and true freedom, because true freedom will only happen when the people make the final decision, have the final decision-making authority, veto right over our governments when our governments go rogue. And that's important, and that needs to apply in Palestine and everywhere worldwide, so that we can finally have no more wars, enjoy true peace and solidarity, and help each other out, and take over all of our natural resources out of the hands of the elite, and to stop the WEF in its track, and to lock up all of those that have contributed to a mass depopulation scam of the last 40 years. Thank you. We'll see you at the Powershift at the powershift.ca or the cpu.ca. And please sign your Convention of Consent and let everybody know. And please become a CPU member. Thank you. I'll just show you something before we go and finalize our housekeeping. And okay, here we go. We'll see you again next time.
Dive into 2024 with the CPU's dynamic campaign, set to energize Quebec and Ontario by reaching 75,000 homes with our empowering message. Every contribution you make is pivotal, driving this ambitious initiative forward and ensuring our information lands directly in communities via Canada Post. We extend special thanks to our dedicated CPU members, whose grassroots efforts amplify our reach. This campaign is your gateway to being part of a significant movement for change. Whether you choose to donate or volunteer, your participation is key to our success. Join us in making 2024 a victorious year for collective freedom and community action with the CPU.